The Senior Reset podcast delivers education and resources to help seniors and their families set themselves up for success. Each week, we dive deep with medical professionals and industry leaders to bring you answers to the questions that matter most. From the latest medical advice to financial strategies to staying ahead of scams, we'll build the toolkit you need to thrive. Here's your host, Joel Stewart.
Hey, everybody. Welcome to the Senior Reset podcast. We are talking resources, education, solutions, entertainment, and training for the senior community and their families. I have with me today Nicole Farmer, my co-host. She's joining us from Dogwood Terrace, a senior living community in Richmond, Indiana, and Lynne Shelton from Shelton Law Associates. And she is going to be joining us today to talk about a very interesting topic that I don't think could ever be more relevant. It's important for everybody, regardless of age. We are talking about estate planning. And for those of you that don't know what estate planning is, it is you deciding what happens to anything associated with you instead of the government deciding what happens with anything associated with you should the worst occur. So I'm going to turn this over to Lynne and ask her, can you go over just what is most important with estate planning? Kind of what is it? Who qualifies for it? Is it only for rich people? How about we start there?
Sure. Thanks, Joel. No, estate planning is for everyone. So no matter the amount of estate, if you will, that you have, everybody has something: belongings, family heirlooms, clothing, household items, memoirs. All of that is part of your estate. And estate planning is basically just setting forth a guideline that you want to be followed in case anything was to happen to you, whether you are incapacitated and still alive, or eventually once you pass, what you would like to have happen with all of the tangible and intangible items in your estate.
So I imagine one of the hardest things when it comes to estate planning isn't the actual planning. It's how to approach communication on the issue. I mean, I know I've had family members try to approach this with me. What does communication look like between family members? Who needs to be talking to who when it comes to estate planning?
Yeah, it is the hardest part, no matter which side of communication you're on, whether you're a kid talking to your parents or you're the parent trying to have an honest conversation with the kids. Nobody really wants to have this conversation. It's not comfortable. Nobody wants to think about losing someone that you love and care about. But it's definitely a requirement to just plan for it. Set aside a time, just like you would calendar a doctor's appointment, calendar appointment with your loved ones, whoever they may be, to say, okay, we're just going to talk about what your wishes are. And that means everything from financial aspects to, whether you want, when you pass away, to be buried or cremated or put into a living forest. I mean, there's all kinds of options in our day and age, and really it's about what do you want, so that your loved ones can honor your wishes.
And who should be, when we talk about who should be looking at estate planning, when I think about it, something could happen to me tomorrow. I'm only in my early 40s at the moment. It's not generally something that's on my mind, estate planning, but as we talked about this before, we jumped on to record this, one of the things I was thinking about is, this is really something that everyone should be talking about. And, when you look at it holistically, this isn't an end of life conversation. This should be at any point in life, a conversation that needs to be had, because it's
Yeah, I'm right there with you on the same age, Joel. And with the traveling that we've done recently, my mom is big on, you need to figure something with the kids, you need to figure something out before you're out of state all the time.
Yeah, hopefully she doesn't get mad at me for sharing this, but I remember early on in my marriage, we went on a trip, my wife and I, And as soon as we were like in the airport, she's like texting a will, like, if something happens to us, we want this to happen with the kids. Hopefully that's not the situation. But speaking of that, Lynn, like, so when we're looking at conveying our wishes, there's probably a difference between conveying your wishes and having it legal so that the government, doesn't just kind of take over and do whatever they're going to do. What does someone legally need to do to have their wishes codified and, legally binding?
Yeah, and it's different in each state, but they need to definitely be in writing, and it needs to be witnessed by at least two people in the majority of the states. And currently, where you're at, Nicole. The aspect of how your wishes are conveyed can be done, through the court or bypassing the court. And that's probably the biggest, I would say, misnomer in estate planning, is everyone thinks that, well, if I have a will, then, it's automatically gonna have happen whatever I put in that will to have happened. And that's not necessarily the case, sadly. All wills have to go through probate, which is the same process you would go through if you did not have a will. And so you have to have the court's blessing and a judge rule that is in fact, the last will and testament of the person that's deceased. And so what that leaves open is the ability for anybody that didn't like what you had in your will to come and, try to get it kicked out as not your last will, and that they had told you something else. And so I would like to always think that all families are just harmonious and joyous with each other, and there's nobody that would ever, file for a disagreement with a will, but that seems to not be, historically the case.
No.
I want to live in your world. That sounds really good to me.
Right? I wouldn't even do that in my family,
Yeah, I get it.
But unfortunately, that's what happens is that, you have to prove that a will is in fact the last will and testament going through probate, which whenever you go through probate, that means you're in a court case. It means that you have a timelines like all other types of court cases that can be months and years to be drug out before they're finalized. And there's all kinds of expenses and court costs that go along with each and every step, just like a regular litigation case would be. And so, wills are certainly certainly better over dying without one. But it leaves interpretation and final judgment with the judge. And so, the thing that I always like to point out to everyone, and you're right, both Nicole and Joel, you're right. You guys should also be looking at this. I tell people that if you are out of college and you have, a car or a CD or furniture or anything else, that's the time to start planning your estate planning, and then just update it from there as life changes. That the only way you can avoid probate is to have a trust. And a trust does not have to go through probate court. It's private. It never has to be actually recorded. So it's all your information is kept private from, the people at large. Whereas a will eventually end up on a court docket and can be looked at what your wishes were as well. So there's, two different ranges that you can record your wishes, utilizing the court or not.
Yeah, my grandpa had a living trust. Him and my grandma put it together. She died first. He changed it after she was gone, but it was situated the way that he wanted it, and things had changed after she left. But it was like he tweaked it several different times throughout my lifetime. Like he was able to go in. It was like a binder, if I remember, like a notebook. And he would go in and change things in it and then take it to his attorney for review, maybe, or something.
Yeah, probably for finalization. Yeah, that's the nice thing about trust is that whoever's trust it is, they are the trustee until they pass away, which means they can make changes to the trust as life happens. So, as kids are born or grandkids are born, or you really just are mad at that kid and you want to disown them. It's like all of those things can happen.
It was really nice because there were, the harmonious thing isn't always the case, but there was a clear-cut picture of what he wanted. So it wasn't up to us to decide or to fight over it. It was up to one person to execute it because they knew that's what he wanted. We watched him change it over the years.
Right.
Well, let's backtrack away from trust just for a second, because I do want to go back to it, but I just want to kind of flush out the thing with wills.
Sure.
So, short of a trust, because I'm sure a lot of people, especially if they've never been in business, and they're not familiar with business entities or trusts or any of that stuff, a trust probably sounds super scary, and they're probably thinking in their mind that it's only for wealthy people. So, we're going to get into that and kind of hopefully make it a whole lot less scary in a second. But when it comes to just basic wills, would a text message count as a last will and testament if it was sent right before an emergency? Like when it comes to conveying last wishes, what's kind of like the best practices in that, short of like establishing like a whole trust and all of that?
Sure. So there's legally 3 different types of wills. There's what's called a holographic will, which is basically a handwritten will. Text messages has not been recognized as handwritten.
Oh, come on.
Yet.
Although it might be in the
yet.
future, who knows? There are statutory wills, which those are basically forms like that you can buy at a Staples or Office Depot type, Form Depot type thing, where it's a fill in the blank. And those always have limits of how much the estate can be worth in order to utilize those fill in the blanks. They're very, very basic. And then there's the attorney created will. And that's obviously fully customized. We're dealing with the assets, of the estate itself and what you have. All of them do require at least 2 witnesses to sign, saying that they saw you sign your will. So basically, they're not attesting to the fact that that's your wishes, but just to the fact that they saw you actually sign it, that this is the last will.
So kind of like the worst is you don't have anything. And then if something happens to you, regardless of your age, the government, goes through probate, and the government kind of divvies everything up the way that it thinks it should. And then a step up from that is you draft a document yourself. You have 2 people sign it, and that's kind of like your basic document. A step up from that is like a legal form that you can print from Staples or from somewhere else. It's a little more, it's more legal than just like a handwritten stuff. You still need 2 witnesses. And then kind of the best is going to a lawyer, having 2 witnesses on that. I'm guessing people at the lawyer's office count as those witnesses. That's the way it works. And you have it on file with them. How much generally does it cost? It obviously doesn't cost very much if you're just printing something out of a printer, but if you go to like Staples, it's maybe a couple of bucks. And then if you go to, your lawyer, I'm sure it's different every state, but what's kind of the general cost for a will?
Sure. So, the fill in the blank forms are typically around $29 or $39.99. That's usually like a page or 2. To have a custom will done with an attorney, I've seen them range anywhere from $500 to $2,500 if they have a length of time for changes and addendum. So like a 10-year package or something like that. Whereas, within that 10-year, you can make as many changes as you need to redo the will.
Well, that's nice. So then you don't feel.
That package, is it set in stone then without the package to change it?
Yeah. You'll just pay each time that you start over and do what's called a codicil. So it's basically an amendment or a change to the previous one.
You can kind of have somebody draft one up as like a one-time off, and then, pay every change, or you can buy a package and just change it whenever you want to over 10 years.
Okay. Yeah.
Right. Exactly. Yep. And then also, I just wanted to mention, if you don't have a will, or if the will is being challenged, it can revert back to just what the statutory code is in the state, which, basically is going to go, if you have a spouse, to your spouse, if you have kids, to your spouse and kids. If you don't have either, it's going back up to your parents and then trickle down through your family tree. And, the thing with that most people don't like, I guess I would say, is that it doesn't leave any room for family that's not directly related to you, or friends, or charities, or if you happen to be in a relationship with significant others. Some states still don't recognize that within the estate planning realm of probate. And so even though you've been together with someone for years, they may not get anything legally. And so that's really important. If you have any of those individuals that you want special allocations to, you really need to make sure that it's in writing so that it can be followed.
So, I can definitely see why wills might be challengeable. I mean, you could be not in your right mind, and then suddenly there's a change to your will that gives all the money to somebody else. Is there something people can do to like enforce the will? Can they have like more witnesses? Have a bunch of different people witness the will? What can people do to kind of reinforce it a little bit? Anything?
Yeah. Many copies of the original. You can file for recording. In some states they'll let you to actually have it recorded. The problem with the overall aspect is that all that your witnesses are witnessing is the fact that they saw you sign it. Not that was your actual wishes or what the pages before that actually said. So it's not like the witnesses are reading through the will and knowing everything that you want to do or not do. They're just saying that they saw you sign this on this day. And so it really is still a document that's open to forgery and open to people lying in court and challenging it if they think it should be.
I was thinking, I do want to get into trust now, but I want to tackle one thing first. Now, one of the reasons people might want a trust and might want to take on kind of the scary boogeyman that is setting up like this other legal entity is for tax reasons. If you have stuff that's valuable, for tax purposes, if you don't have a trust, what generally happens to everything that you own? Like how much does the government take generally?
So I am not a tax attorney. So I'm not going to give you an exact number. But it depends on who it's going to, how much they've received from the person in the past, if anything, or from others. And what other deductions and if they're still working and getting paid. I mean, there's a lot of things to think through. What I can tell you though is typically it is a tax advantage over if you were just receiving that income or that property as an individual, or into just a regular company. There are tax breaks that the government gives to estates.
I know that I'm sure we've all seen the stories of like different states and even the federal government putting in estate taxes when someone passes. And I've seen numbers in news stories of like over 50% sometimes. And I don't know exactly the ins and outs of what goes to those numbers, but they've always been pretty scary to me. I've always thought, I definitely am going to need something besides, just writing a will to protect my assets someday.
Because that's exactly what happens with a will, or if you die, intestate, and you're receiving things, it can certainly be that high of a tax for sure.
All right, so let's transition to trust now. So can you just go over what a trust is exactly, like in its most basic form? What is a trust?
Sure. So a trust is its own legal entity. And it is also a legal writing of what you want to have happen when either you become incapacitated or eventually when you pass. And so it is very much so like a will, with the difference that it is a document that bypasses those estate taxes that we were just talking about, because the document itself, even though you still fully own everything that's in your estate, the government looks at it as if it is no longer yours because you've identified it for a beneficiary. So it's yours, that you're the trustee or the person in charge of it until you die, but it's not yours to be taxed any longer because it's for a future person. You're just holding on to it temporarily until you do pass. So it's this amazing little document.
There's a joke I like to make, and it's when people are talking about it, I say, hey, now corporations are people too.
Right, exactly.
Yeah.
It's just like a corporation as far as
Well,
it's a different legal entity now, but it's something that you control.
yeah, it's I guess one correlation way of putting it is when you set up a trust, it's like setting up a person that's not a person. Like instead of you owning this assets or owning whatever it is you put in the trust, it is the trust owns it, just like the trust is an actual person.
Right.
And so, if something does happen to you and your stuff is in a trust, well, the trust, nothing happened to the trust. The trust still lives on. I guess correlating it back to business to people that might have some kind of understanding there is that any business generally has like a something that happens. Like if the person that owned the business passes, then the ownership of the business shifts. There's something in there, but the business itself doesn't disappear. The business is still there. It's just the person that owns the business shifts. And when you're setting up a trust, you're setting up a person that is it's like a virtual person that if something happens to you, the ownership of that trust shifts, but the trust itself, nothing happens to it. That's probably a sort of description of it, or am I making it more confusing?
No, that's great.
Well, I have a question about that, and maybe, so how does a trust factor into someone that say like has benefit, like doesn't want to get rid of their house and their things to qualify for Medicaid? Like they need it, but they still want to hang on to their assets, and Medicaid is saying, well, you own this, this, and this. If it goes into a trust, does it still count as their assets, or is it now a separate entity?
The separate entity.
Interesting.
Yeah.
So I guess to take that one step further, if they get money from other sources, like if they have other businesses and they just wrap those under the trust so that the money goes into the trust and doesn't go into their personal bank account, would they still qualify for Medicaid because they're not officially recognizing that income themselves? Is that
possibly? I don't work
I'm
for
just
Medicaid.
theoretically.
But in general,
we have a lot of clients that do. I'll put it that way.
In general, just like, if I take all of my money and I dump into a life insurance policy, it's going to grow benefits. I'm not going to have to count that for financial aid for my kids when they go to school.
Right.
So like for anyone that legitimately wants to set up a trust anyway, like I want to make sure everything's in order for my children and everything's in their name. And then later down the road, I don't want to give up my house and my car and whatever, but I've put those into a trust. I don't necessarily have, but I don't have a lot of income. So now I qualify income wise, but those assets don't count against me. Because I just talked to a lady yesterday with this exact same situation. She doesn't qualify, but she can't afford services.
Right.
But she doesn't want to get, she said, I'm just not signing my things over. I worked for those my whole life.
Of course. Why not? Why would you want to? Right. Yeah.
I want to touch on one more.
Whatever's in the trust, you don't technically own anymore. It's your beneficiaries, right? You're just managing it.
You've been very helpful today.
Well, I have a family member that was looking at estate planning, and they wanted to pass, their assets down to the different family members. And one of them was special needs. And if they had assets, they were told they wouldn't be able to qualify for government services. And so they first started looking at a trust, because if they needed money, if they needed something, they could pull money out of the trust to cover it, as long as the trust said in there what it could be used for. But it wouldn't count as assets and, make it so that they wouldn't qualify for government services. So I know that it can be used in a lot of really interesting ways to help someone qualify for government services, whether it's for special needs reasons, the person couldn't manage the resources themselves anyway, or if, like you were saying, somebody just needed to get assets off the books to get some extra assistance in daily living.
Right, absolutely. And I just want to also just, mention that to people that are setting up trust when they're young, but also to parents and grandparents that are thinking of their children and their grandchildren, is that the nice thing about trust is that they're fully customizable. And so when you go through, a very lengthy questionnaire that talks about your wishes, the two things that you want to think about is, control and the financial aspects when you're thinking of your beneficiaries, as far as who's going to get your assets and the people that are the beneficiaries. In many cases, kids or grandkids, depending upon who's doing the trust. And those individuals can be different. So, if you have little ones and you're like, wow, my sister would be amazing at raising my kids, but she's not known for keeping a balanced checkbook, that kind of worries me. The individuals that takes care of the financial aspect of helping to care for the kids can be an entirely different person. It could be, your brother-in-law who's a financial planner. Okay, he's gonna handle the income of making sure that my sister has enough money to take care of my kids, because she's the nurturing parent that I want to replace me. But I don't want to have to worry about them, being in a box by the highway. It's like, so, you can split over control and financial aspects to that whenever you're thinking about a beneficiary. And the same is true. And I talk to a lot of seniors, which is funny now, because that's, really close to my age as well now, of, when you think of your kids and who you want, or your friends or other family members that you want to have your assets when you're gone, not everybody is responsible in life at the same age. And so and even if you're thinking of little ones, you don't have to have it set up to where they get to inherit, when they're 21. If you have two kids that, one of them is just, that the instant that they get their hands on money, that it's going to be gone and they're not really going to have anything for a future. You can tie to inheritance and gifting at different life events or different ages, whatever happens to be applicable for one. So if that one wants to be a doctor, you can have it, drip money in to help go through college for many years before they actually get, any lump sums. Or if they're, just not as grown up as their sister or brother, and they're in the way that they handle their finances and things, you can have it wait. We did one the other day where one child wasn't going to be getting their inheritance till they were turned 35, or were married with a child, needed to have at least one child because the grandmother felt sure that at that point they should be grown up.
When they're old enough to run for president, they can have some money.
Right.
I like it.
So quick question on this is,
Sure.
So when you're talking about who can be the person that's in charge of dispersing funds, so somebody can have funds allocated them through the trust, but you can set up somebody else that has to approve expenditures. Does that person have to be in the family, or can you ask like a financial organization or a legal team and say, Shelton Law Associates, I want you to ultimately approve any financial disbursements that come from this side of the family?
That's a great question, Joel. It does not have to be a family member. There are organizations out there that do this specifically, that do trustee services, and handle that aspect for the family based upon, written instructions, obviously, before they pass. My law firm does not do that because we would be drafting trusts and things, and we just don't want to step into the middle of a trust we didn't draft. But we can certainly assist in directing those companies if you want a financial company to be that trustee. And we can assist with, what the actual person's wishes actually were beforehand, and in that regards. But, when you're doing your trust setup, you should be asked, who you would be the first trustee until you pass, right? And then you need to think of your successor trustees, and you need to think of multiples, because, the person that you identified may not outlive you, number one. But they also have the ability to say, no, I don't want that responsibility, or I don't think I would be good enough to do it. Or if, the beneficiaries that you're leaving everything to does not get along with that person, that could create a personality conflict. We've seen people refuse and quit being a trustee for that reason, as well as it's just too much emotional aspect. So you really want to kind of think deeply when you are thinking through who are your successor trustees, and always end with, kind of a generic, like they can pick a corporate trustee or a company that does trustee services to actually make sure that your wishes are followed per the document.
We talked a little bit about how, or who can decide what happens with the trust assets. And we talked a little bit about how people can put all of their assets inside of a trust. But what does it look like to pull assets out of the trust? So say I'm looking at retiring. I put all my assets in a trust. So I qualify for Medicaid. I know that I can get some money out of the trust over time without breaking the rules. Does money that comes out of a trust count as personal income, or what does it count as when you pull money out of the trust for whatever it is you want to spend it on?
So it depends on what it's spent on. If you're just paying yourself like a salary, it may or may not be counted as income, because you're allowed to take administrative fees annually as well from a trust before it could potentially be counted as income. So it depends on how much and where you deposit it. If you are just selling things and purchasing additional items, that's not income, because you still have full control over it, as if it's in, your bank account still, so to speak. And you can make all of those changes with whatever you own that you wish to have done. But it could be income, depending upon what you're paying yourself and how much, you're taking out, and how clever you are at describing what it's for.
And I'm sure that's where Shelton Law Associates comes in. It's helping you be clever. So.
Creativity.
I do want to get into some creativity things. I think it'd be fun to brainstorm some stuff. It's what I love to do. But before we get into that, I want to backtrack a bit. So someone's out there listening to this and they're saying, wow, this trust thing seems really great. Maybe I have a rental home or something. I want to make a trust. What does someone have to do to make a trust?
Yeah, so to make it, it needs to be created legally with all of the answers that's required of all of the what ifs that go through. What if I'm not dead? What if I'm just incapacitated? Who's going to be the successor trustees and all of that? And it needs to have an asset. So you need to put at least one thing into the trust. And that can be something that just is in title. If it's an item that has a title, like a car or a boat or whatever, or house. Or it can be a bank account that you open up and you have, at least the 100 or 50, whatever your bank requires a bank account to be opened with. And it needs its own EIN or employment identification number, because it is its own entity from there. And then in order to be able to do any of those things, you'll need a certificate of trust. And a certificate of trust, you can just kind of think of that as like a summary of what your trust actually says, that can only be done once the full trust is completed legally. So it's, it's the big long legal document. It's kind of, you can think of it as an agreement of all of your wishes and instructions of all of your wishes. And then the certificate of trust summarizes that and is notarized. And that's what people receive, not your full trust, which is how it stays private. So it just has basic information like what the legal name is and who the trustee is and the successor trustee, so that they know that, but not really any of your assets or who it's going to is not in that certificate of trust. It's a much shorter document.
Well, the more things you say, the more paperwork is virtually piling up in my mind on trying to get this thing together. It sounds like this isn't really a do-it-yourself kind of job. So assuming somebody decides to go to a law firm like yours to set up a trust, what is it that I guess they have to fill out a bunch of forms so that they can tailor it exactly the way that they want it, and you kind of take care of the paperwork. Do you take care of the paperwork for, like, say, transitioning a car or a house? Like, all of that is kind of handled as part of what you do?
Absolutely. Yeah, you bet.
And then,
All transfer forms and things come at the end to actually transfer things into the trust. You bet.
so for like a basic trust, like say somebody maybe has like a house and a car or something like that, how much does it generally cost to put one of these trusts together?
Ooh, that,
I mean, you can say 500 to 10,000. I'm just, or
all
100,000. I don't know.
right,
But
I mean, ours is 5,000 flat fee for everybody. It's a 10-year package. So that means 10 years, you can make changes as often as you want, as life happens. And we just have a flat fee for everybody. Across the country, most of the time, it's not a 10-year package. Most attorneys and law firms charge anywhere from 7,500 to 15,000. And then whenever there's changes made, or if somebody passes and the successor trustee calls for questions, even how to make sure that everything is followed properly, they'll get charged billable hourly rates. And those typically, range anywhere from $375 an hour to, we've seen people being charged as high as $775 an hour for changes or even just questions answered, which personally I think is disgusting, but that's why we have a flat fee.
well, it's not it's not like super inexpensive. So somebody really doesn't have a whole lot of assets, a will is probably the right way to go. But there are a lot of advantages to putting together this will or the trust. For somebody that does have some amount of assets that wants to put together a trust, it sounds like there's a lot of advantages to it. It is complicated, obviously, but it doesn't sound insurmountable if they're working with a law firm to help them handle all the paperwork and putting it together. And once it's put together, it's really kind of fire and forget, unless you want to make any changes or pull any money out of it or something like that. Is that kind of a fair summary?
Yeah, it really, actually, it sounds very complicated. And it's really not. The ability to create the trust, I mean, it's a lengthy questionnaire that we utilize and most attorneys utilize to ask all of the what if questions. Do you have any insurance policies? Do you own a home? Do you have kids? Were you married before? So a lot of it is a fill in the blank or a check, of a yes or no aspect. But it's not something that somebody would sit down and just do in an afternoon. We always tell our clients to just, go at it slowly, sit down with a good cup of coffee or a glass of wine or whatever, it relaxes you, and just think through, each person in your life that you want to honor and that you love, and think through what you have currently, and, who you would like to get what. And, if they weren't there, then who would you like to get it? And it really is, also, I think, a blessing. It's kind of it's one of those weird things where you don't want to do it, but then when you do start doing it, you realize how blessed your life is and how many loved ones you actually have. So it can really be a good experience as well when you take your time at it.
You raised another question I'd been meaning to get to is, so life insurance policy. So if somebody has a life insurance policy, it could be for, $100,000 up to much more than that. Is that something that you can, that you would set up a trust for? Even if you don't have a lot of other assets, you could set up the trust to be the recipient of a pretty substantial life insurance policy. And I'm sure that there's probably, a lot of benefits to setting something like that up.
Absolutely. Absolutely. Yeah. We always recommend the life insurance to change the beneficiary to be your trust, so that you can make changes as needed to your trust. And you don't have to worry about life events that you should have changed your insurance policies. There's all kinds of horror stories of people passing away and, ex-spouses getting that insurance money because somebody forgot to change who the beneficiary was when they got remarried. And horrible things of that nature. But if you have it always go to your trust, then, then within the trust, you can make those changes easily. And somebody that was divorced would not be a part of that trust by law, unless specifically stated.
Got it. All right. So I guess playing around with the format of the trust. So you have this other kind of entity. Corporations are people too. So you have this entity that has your assets, that could be the recipient of your life insurance policy. Let's just throw out a theoretical example. Let's say you're retiring. You've got a couple rental properties. So you put those rental properties in a trust. And it sounds like the income from those rental properties go into the trust. You don't recognize them as income. Repairs to the properties would come out of the trust. If you wanted to use that rental income, could you get a loan and have a trust buy additional rental properties without you personally doing the things yourself? Like, how do you grow a trust and grow your assets inside of a trust? I mean, we all hear about wealthy people doing it all the time, but it doesn't sound like you have to be all that wealthy to really take advantage of some of this.
No, you definitely don't. With real estate in particular, we would recommend that the properties are held by an LLC first, but that the LLC is owned by the trust. And that's just to put a level of protection, just in case there was ever a lawsuit or somebody got hurt on the property or anything of that nature, because you don't want a trust being sued. Not that they would get anything, because it's not yours. So but it becomes this big, long, expensive battle to get nowhere. So it's just easier to protect it. And then absolutely, you could take, the LLC is the one that's buying the property, and the trustee is signing on behalf of the LLC because the trust owns it. And you're growing those properties. And then like I said, as the trustee, you're paying yourself administrative fee to oversee the trust. But also, if you are, if you're your own property manager, you're handling those real estate properties yourself, or renting them yourself, or whatever happens to be applicable, you can also receive a salary through the LLC. So there's ways to get income from them as well that, will keep you in lower tax brackets, but it's still owned by the trust as well.
Now, I know you're not a tax attorney, but so money that comes into the trust from something like, say, it sounds like a trust can be a holding company. So instead of having like an LLC holding company, you could have a trust be a holding company that has multiple business entities underneath it that all could be generating revenue. Say they're real estate, or say they're business holdings or investment holdings or whatever. So the money feeds back into the trust. Is the trust treated as like a for-profit entity that pays corporate taxes, or is it like a nonprofit where you don't have to pay taxes as long as the money stays in the trust? Is that a fair question?
Closer to a nonprofit. Yeah, it's closer. I mean, it has its own rules, but it's closer to the nonprofit, not like a for-profit, because it's not really yours. It's for your beneficiary.
Right. So
Even though it is yours.
So if someone used a trust as, say, a holding company, it sounds like if they had that having multiple investments, they could reinvest through it and receive some pretty significant tax benefits by not recognizing that as income that's coming through it. And it sounds like something that almost anybody might want to do regardless of age, just for that reason alone. Is that?
A lot of people do.
A lot of people do. Well, I know whenever you hear wealthy people talk about their assets, they're always in trusts. So that probably there's a game there that gets played, I think.
That's why,
Wow.
that's right. Exactly how that happens when you hear of wealthy people that have, or you see their tax returns and they're a very low dollar amount. You're like, no way.
Like, it's a billionaire, but he doesn't pay any taxes. Well, all his assets are in a trust, and he doesn't technically.
Not really his.
Oh, okay.
Building wealth for future generations.
Yeah.
You just happen to get to use it while you're here.
All right. So getting a little darker in the conversation, when it comes to like healthcare directives, which, can get, not quite as fun to talk about. Is that something, can you just talk for a second about what healthcare directives are, and then maybe talk about the difference between having them laid out in a trust versus a will?
Yeah, absolutely.
Or if you use them in a trust, I'm not sure.
Oh, absolutely. Sure do. Yeah, but let me backtrack just 1 second if I can.
Yeah, go ahead.
So we were talking about costs, the cost difference between a will and a trust. And obviously a trust is more expensive. But the thing that I didn't get to point out is that in fact, the majority of states now have statutory fees for probate for attorneys. And what that basically means is that when either you have a will that needs to go through probate to be acknowledged as your last will, or if you die intestate without a will, they've put in place statutory fees for attorneys to be paid, because most people, the majority of people, don't have an attorney already picked out to handle the probate process. And because they don't realize that they need to. Most people think that wills, if you have one, that you're good, you don't have to go to probate court, because probate court is just for people that don't have a will. And that's not true. And so because of the statutory, as an example, on a $400,000 estate. So if absolutely everything totaled up to $400,000 or more, the low end of statutory fees that an attorney would be paid from your estate is $11,000. And that's just to the attorney that's handling it, not any of the court costs at all, which can come up to be about an additional 50% of that.
Wow.
So, yeah. So even though you think wills are cheap, they're kind of more expensive.
It's just paying it later instead of up front.
Exactly. And you're not paying it, but your loved ones are. Whoever is going to be, the executor of the will.
Well, who likes those people anyway?
I know, right?
I'm glad you added that. That's an important consideration.
It is.
When you're looking at the total cost of one versus the other one.
Right. But yeah, I just wanted to make sure that was known as well. And then let me get back to your question. So the advanced healthcare directive. So basically what a healthcare directive is also your wishes. So it goes along with, and you should have one even if whether you do a will or you do a trust, or even if you don't have either one of them, at least have a healthcare directive done. It is a separate legal document that tells your wishes around healthcare and healthcare items. So it's going to talk about your choice of, whether you want your life to be prolonged and put on, air support, to be put on and receive food and nourishments, whether or not, you want to have organ transplants done, if you want that, if it's needed. And also who specifically is going to make those decisions for you if it's something new that isn't in the document yet. So, an example, back in the early 2000s, we had not had a court case that had to decide whether or not somebody should receive food intravenously. It was just thought to be life, a life prolonging, just as if, you were on a respirator. But it came down to being an actual thing that they had to decide on, and they had to have a court decide it, of whether or not to remove food and basically allow somebody to still be receiving oxygen, but to starve to death if they remove the food. And so you need to ensure that all of those aspects of what your wishes are placed in that document. And, it includes, whether if your heart stops, whether you would like them to try to start it again. And also, whether or not, if there's any experimental medications that are being tested, whether you want, if there's a likelihood that it would help you, whether you want those also. And it's not like a checkbox where most people are like, I agree with all of that, although some do. Oftentimes some people think yes to some and no to the others. And an advanced healthcare directive is probably the kindest thing that you can do for your loved ones, because none of those decisions are ones that anybody wants to make about somebody that they love. And so it really should be done, even if you don't have anything else. That piece of it really is important, and is just an act of kindness, really, to those people that care about you. And secondly, the other document would be a financial power of attorney, and that is very, very important as well. Because of the fact that if you do not have one of those, and if the person that you want to be in charge of your finances is not already on the bank account, they will not be able to get access to your funds to be able to continue taking care of things. And that doesn't really even matter if you've passed away. You could just be, incapacitated. We saw this, unfortunately, a lot with COVID, where people were in the hospital and they couldn't do all of the tasks that they needed to be able to do from the hospital, and nobody could go in to see them to get anything signed either. And, if you didn't have a power of attorney, or if you weren't already somebody that was listed on a bank account, the funds could have been there to make the house payment, to make the car payments, to pay your kids' college funds, whatever the case may be. But if they can't get to it, then, they're having to cover it out of their own personal expenses, if they can, until they can get access to those documents through the court.
So how would someone find those documents, financial power of attorney and the advanced healthcare directive? They need to go to a lawyer for that, or can they find those documents online? What would someone do to try to get those set up?
If they are doing a will or a trust with an attorney, they will make those for you. There are forms, again, standard forms that you can get at like Staples or whatever, that if they're basic, then you can kind of fill in the blank. And, there are forms online that you can find templates and things for, but again, they're going to be basic. And so they may or may not answer the question about experimental drugs or, something else in there. It may just be about resuscitation and maybe food. They're kind of basic templates that I've seen.
Are there any other considerations people should have besides we've talked about, the different ways you can try to set up a will. We've talked about setting up a trust, and we just barely scratched the surface, I think, on playing with a trust and how it can be used. But then we talked about the power of attorney and, setting up a healthcare directive. Is there anything else people should consider when, and honestly, like, especially with COVID, kind of highlighted that this is something that any adult should probably be looking at because anything could happen to any of us at any time.
Right.
So is there any other things that we should be thinking about when we're looking at estate planning?
Honestly, everything that they love. So what happens to pets? What happens to, if they're in the country, livestock, crops, businesses, children with special needs, young children, grandchildren, and really the one that everybody always forgets is what happens if I don't die? What happens then? How should the assets be utilized if I can't make the decisions any longer, but I'm still here? And that needs to be a consideration as well, so that people can be taken care of, and have the assistance that they need at whatever level they need, and be able to be taken care of and still have, life to the fullest that they can.
So hopefully I'm not putting you on the spot here, and this is just changing directions completely, but what's the funnest thing you've seen somebody do with a trust? I'm just super curious.
Okay.
Like, my brain's kind of turning and I'm thinking of like a dozen different like fun things to do with it. I'm just curious. Is there anything you've seen you could share with us?
I would say I love doing grandparents' trusts. I mean, I just love them. You can prompt the generations below you to be better people and to have better careers and lives and to have a reason.
You don't give me grandkids, you don't get any money.
I have seen grandkid provisions for sure. I like to, honestly, I would say the was a grandparent that had 6 children. All 6 children. It was actually a gentleman that did this, that had varying degrees of responsibility, he felt. And so he trickled out their estate through different life events. And so, if they got married, then they got a portion. If they had a kid, they got a portion. If they were involved with a nonprofit for at least 200 hours a year, then they got a different portion. If they did civic events, just helping out the community, then they were, once they achieved that number of hours, then they got another portion. And that was really a fun way to see kind of the encouragement from the grave, if you will, that they wanted to see their kids. And he felt very sure that they would all achieve 100% of what they would receive, but they would receive it over, their lifetime, because they were pretty decent goal involved in there. And then we've seen a lot of fun pet special trusts that are carved out of the trust for pets. And, taking care of them and ensuring that they get groomed every month and, special foods and not just treated like, oh, I got the dog, that I didn't want, but actually we're being taken care of and loved as well. So,
Yeah.
I mean,
Well,
that's the nice thing about trust is it truly is fully customizable.
yeah, my wheels keep turning. We do have to cut this off at one at some point, but I do have another thought. So what about setting up, like we talked about life insurances, how they can pay out to a trust, how income producing assets could be put into a trust, investments could be put into a trust. Do you see a lot of people create trusts and say, and it's almost like they have like the way colleges have these funds set up, where they just say, you're not touching the seed funds, but the revenue produced by like say a life insurance goes in and you say, we have a $500,000 life insurance policy. It goes into the trust managed by XYZ fiduciary, and the profits, like 50% of the profits go dispersed and through whatever channels, 50% get reinvested. Do you see that kind of stuff a lot for trying to create
Absolutely.
generational wealth through a trust?
Absolutely. Yeah. In fact, it's called a spendthrift trust. And so it's, you're dripping, the interest and the income that's being created without actually, attaching anything to what's called the corpus, the main portion, the principal, if you will, of the trust itself, so that it can maintain and continue to produce more income next month. And so it's like receiving, a monthly salary from the trust for your beneficiaries.
And can people set it up so that, other family members can contribute to this? Like if somebody wanted to create that, like say a big family wanted to try to create like a big investment trust and family trust, where like everyone in the family can contribute to this money pile that kind of grows for the benefit of the family.
Absolutely. And then you can carve out pieces, of your individual pieces out of it for each family member that's putting in, can be sub trusts, if you will, as well. So yeah, you can create quite the trust tree.
All right. Well, I appreciate you coming on and talking with us. Nicole, do we have any questions in the room that people want to ask? I need to
I thought you could get a free will.
A free will? She's not the living trust, but she's saying she thought you could get a free will done. Like someone would do one for free.
There may be a nonprofit that offers that. I'm not.
Maybe like a nonprofit organization that you could go through.
Yeah, I guess.
Okay.
Also, I don't have anything valuable, so my kids will get everything.
Well, I think that's kind of what she's saying. Even if it's not anything that you don't deem as valuable, if it's anything that you care about, putting it in writing in a trust versus just letting the government have it say if there's any kind of disputes. Am I explaining that right? Kind of, was saying that right?
Yeah.
That's kind of, even if it's not anything that you think maybe I would deem valuable or he would deem valuable, if it's valuable to you and it's, something you want.
I know that it's going to go to all of my kids. My kids are not selfish.
Okay.
My kids.
So your kids will divide it up and there won't be any fighting or.
I don't think so.
Okay.
They shouldn't.
Yeah.
Because they bought me all the stuff that I got.
Okay.
They bought the stuff that I got it.
Yeah.
So,
and hopefully that works out too. Yeah.
So, hey, Lynn, how can someone reach you if they're interested in this? I mean, they can go to somebody local, but they could also go to Shelton Law Associates. What's a good way for them to reach out to you if they're interested in setting up a will or trust or something along those lines?
So they can call us to set up an appointment, or they could go to our website, which is sla.law. There's no .com, it's just SLA for Shelton Law and Associates .law. And our you can maybe put in the chat our phone number or something that they can have, which is 512-535-0090.
All right, we'll make sure that goes in the show notes. All right, well, thank you for coming. Any last thoughts?
Thank you, and I appreciate it. It was very, very informative.
yeah.
All righty, thank you for your time today.
Welcome.
Thanks. Have a good day.
Thank you. Bye.
You've been listening to the Senior Reset Podcast. If you found today's episode helpful, please consider sharing with the seniors in your life so they too can live stronger, healthier, and more connected lives. Find all our episodes or submit your questions at signalhg.com/podcast. This podcast is intended for informational use and not as a replacement for medical diagnosis or care. Always consult your doctor if you have a medical issue.